All right, so we're going to go over chapter 9 today. It's the only chapter we're going to cover. It's a long chapter, a lot of info. We're going to take our time here because this is one of the most important chapters when it comes to not only testing, but in real life, okay? It's one of the most important chapters in this profession. And we're going to start with this word. Agency. What does this mean? Forget real estate. When I ask about what a word means, it's the word itself. Okay, so not real estate agency. What does agency mean? Who knows? A company, okay? A group of people, okay?
Like
Specialize in a specific thing. That's what specialization means, in something specific. Lacey says business or organization. Anybody else? That's the wrong answer, by the way, but I want to get to feel of what do you think it might be? Agency.
Agency to do some things and have the right to do it.
The agency to do something they have the right to do it, kind of. You're getting closer to it.
Like the permission.
Aha. Now we're getting to permission. Getting closer. We went from rights to permission. All right. Agency. Don't Google. Don't read. Just I can go from the smiles, like I know they were searching. Guys, agency. What does it mean to be an agent? That means you are representing something. Okay. In this case, agency means employer, employee, relationship. Employer-employee relationship. See, when somebody hires you to be their agent, right? They hire you, they are your employer. They're employing your services. Isn't that what the seller does and the buyer as well? They're employing your services. So technically you become an employee of that person. Even though you're an independent contractor, it's still your services that are being employed. They hire you specifically. All right. So agency is the relationship between the party that was hired, right, and the principal, which is the person that hired you. We're going to go over that. But you got to remember, agency is a relationship, employer-employee relationship. So if it's a real estate agency, that means somebody hired you to do what? Somebody hired you to do real estate? Real estate is done. We went over this. Real estate is what? Real estate is property. That's it. No. Real estate is not everything. And not everything is real estate. Since you brought that up, Masha, I want everybody to tell me, what is real estate? Transactions? Nope. Real estate is not transactions.
And the ownership to land.
Say louder. It's land and what else?
The ownership to land.
Milton, real property. We're getting closer. So we went from land to real property. What is real estate? Louder.
The ownership and the rights to the land.
Ah, we're getting closer. Rights to the land.
Rights.
And property. Okay. So real estate, if you guys remember, is the bundle of rights. Right? Has to do with the bundle of rights. So we have rights to the real property. That's what real estate is. So we have land, by definition, is the surface, anything below, anything above, and everything that's naturally attached to it, that's land. Real property is land plus human-made improvements. And real estate, we're back to the sticks, yep. And real estate is real property and the bundle of rights. Okay. What are the bundle of rights? Decept, yes, you should know this.
The right of the
To deceive people. Possession, yes.
enjoyment,
enjoyment,
exclusion,
exclusion, control.
possession,
We got that.
oh.
Disposition, thank you.
And that's all.
The right to let go of the property. Very good. All right, so that's real estate. It's real property and the bundle of rights. Good? Yes?
Yes.
All right. So what is real estate agency? Is when somebody hires you to help you transfer those rights to somebody else. That's pretty much what it is. You're helping a seller get rid of those rights. I don't want them anymore. Give it to somebody else, to a potential buyer. Or you have a buyer that wants to buy those rights. Okay. So real estate professionals and transaction parties. Yes, but we were talking about real estate. We didn't talk about the transactions yet. So real estate professionals and the parties to the transaction parties have a complex relationship. Real estate professional can represent the client as an agent, acting as a fiduciary, and we're going to have to learn this word, very important, and is subject to legal and ethical requirements to protect the seller, the buyer, and the transaction. There are different types of real estate agency relationships when it comes to potential representation of clients or customers. And there's a difference between clients and customers. There's a huge difference. We're going to go over this. We're going to start with agency law. Agency law. Now, agency relationships in real estate fall under three different laws. There's common law, statutory law, and administrative law. Common law is pretty much rules established by tradition and court decisions, so precedents, right? Statutory law is when we look at these precedents and we say, you know what? We're going to make this part of legislature, so it becomes law. Administrative law is by an administrative body, so rules and regulations set by, for instance, the Real Estate Commission. Okay, so common law is what's commonly or generally accepted based on previous court decisions, or what's expected. Statutory is a state made it a law. Administrative, it's rules and regulations created by a Real Estate Commission or a real estate department of that particular state. The most primary of relationships in real estate brokerage is that between the client, the broker, and the client. The relationship known in law as the agency relationship. In every state, a body of law, generally called the law of agency, defines and regulates the legal roles of this relationship. The parties to the relationship are the principal. Okay, so underline that. The principal, who is the client. We have the agent, who's the broker. Okay, and then we have another party, which is a customer or third party. There's a huge difference between these, and you need to know them. There's the principal, which is a client. There's the agent, which is the broker. And then there's a customer, which is a third party. We're going to define all of them in a little bit. Yes. Client is not a customer. Nope. We're going to define that in a little bit. That's why this chapter is so important, because depending on how you're representing or how you're hired, right, you got to be very careful in your actions. Okay, which could create an implied agency and make your customer a client. I know it gets confusing, but we'll get there. Amir says customer would be the buyer if you're representing the seller. Could be. I could have two clients. I could have two customers. But yes, it could be. Absolutely. All right, the laws of agency are distinct from laws of contract, although the two groups of laws interact with each other. For example, the listing agreement is a contract. A listing agreement is a contract and establishes an agency relationship. Thus, the relationship is subject to contract law. However, agency law dictates how the relationship will achieve its purposes, regardless of what the listing contract states. The essence of agency relationship, right here, is trust, confidence, and mutual good faith. The essence of agency relationship is trust, confidence, and mutual good faith. So when somebody hires you, right, they're entrusting you and confiding in you in what their ultimate goal is or needs. Okay. But there has to be mutual good faith. So they're hiring you for the purpose and they'll help you accomplish that purpose as well. The principal trusts the agents to exercise the utmost skill and care in fulfilling the authorized activity and to promote the principal's best interests. The agent undertakes to strive in good faith to achieve the desired objective and to fulfill the fiduciary duties. It is important to understand that the agency relationship does not require compensation or any form of consideration. So we're going to talk about this also in a little bit, because a compensation does not define agency relationship. Who pays you does not determine your loyalty. Let's put it like that. Who pays you does not determine your loyalty. So you could be hired by the seller, right? And usually the seller pays for the commission. But if you're hired by the buyer, are you going to treat the buyer less than anybody else because he or she is not the one paying you? No. So the compensation is not what makes the relationship. Okay. So let's go over definitions real quick. Common law and statutes define agency as follows. An agent is a person authorized to represent another's interests when negotiating with a third party. Real estate sales associates are the broker's agents. Okay, remember I told you that who represents the clients? Even though we knock on that door, who represents the clients? The brokerage does, right? So if you work for RE/MAX, it's a RE/MAX listing because RE/MAX represents the client through the broker. And then we are agents of the broker. So we also represent the client, but through, again, the brokerage. In real estate transaction, a firm's broker is the client's agent and may share this responsibility with the sales associates. Sales associates usually have the same relationship with the client as the broker. Due to the number of in-house transactions, the same firm representing both buyer and seller, a sales associate can represent the buyers as the buyer's designated agents, even when the sales associate firm also represents the seller. So as you know, we could represent both sides. That's not a problem, but there's a condition here. We're going to go over in a little bit. There has to be disclosure in order to represent both sides. Yes.
Actually, look at that.
We will. All right, the word principal. The word principal, very simply, is the person who hires the agent. Principal is the person who hires the agent. Principal is the person who hires an agent. To represent their interests, meaning that the principal is the client. So the person who hires you is the client, the person to whom you owe specific duties, as we're going to go over in a little bit. Principal and client mean exactly the same, and it's different from customer, which we're going to go over in a second. The buyer, seller, landlord, or tenant are considered the principal in the real estate transaction when hiring an agent. If they don't hire the agent, specifically hire the agent for that purpose, then they're not clients. Now, agency is a fiduciary relationship between the principal and an agent that authorizes the agent to represent a certain principle in one or more transactions. Again, think of it as employer-employee relationship. Fiduciary is a relationship in which the principal holds the agent in a position of trust and confidence. And now the difference between the client and the customer. Client. Client is a real estate broker's principal, we already know, for whom the broker acts as an agent. We already got that. But what is a customer? A customer is a third party, non-represented consumer who may receive some service and is entitled to fairness and honesty. We're going to go over this over and over and over today. A client is somebody you represent. A customer is somebody you do not represent.
Can you give an example of a customer?
I will. Make sure your name matches who you are, please, on Zoom. Guys, make sure you're on cameras. Very, very important. So what is the difference between the client and the customer? Let's say a seller hired me as an example. Okay. A seller hired me to list the property and represent the seller to the best of my abilities. Then the seller becomes my client, also called what? Principal. Okay. Now I hold an open house. Okay. And people come through the door. A lot of people that I do not represent. These are customers. I do not represent them. Got it? Simple as that. It's as simple as that. But now we're going to complicate things. You can help a customer put a contract. You can help a customer go through the transaction all the way to the end.
Then you become your client.
Maybe. That depends on the actions. We'll talk about it later as well. But think about it this way. If you work for a restaurant, there's the example I've been giving for 7 years. If you work for a restaurant, you ever heard the phrase, the customer is always right? Do they say the client's always right? Customer, right? Okay. So I work for a restaurant and you walk in and you sit down and say, Bruno, I want to order the steak and fries. Okay. I bring in the steak and fries and you're like, it was delicious, but I don't want to pay. Okay. So you sat down, you ate, and now you don't want to pay. Customer's always right, right? Not always. Who do I represent?
Restaurant,
The restaurant. So who's my client?
your boss. I don't know.
Whoever hired me, the restaurant. My client, my principal, who I must uphold the interests, is the restaurant. Am I going to say, hey, Fernando, don't worry about it. Just go out your merry day. Don't worry about it. You don't have to pay anything. Don't worry about it. Is that what I'm going to do? No. Who do I represent? The restaurant. So I said, Fernando, I really can't do anything about it. I can call the manager and see what the manager says, or the owner, see what the owner says, but I cannot do anything because I work for the restaurant, not for you. I'll do my best to serve you. I'll be fair. I'll be honest, but that's all I can do. You are a customer. You're not my client. You see the difference? Who do I represent? Whoever hired me. You got it? All right. So in real estate, it's the same thing, but you could actually represent both of them. Let's say somebody walks in the open house and I ask, hey, Alexis, do you have an agent that you're working with? And they say, no. Great. So here's the thing, before we proceed, so as a real estate professional and representing the seller, I have to disclose this to you. Before we proceed, think of it as the Miranda rights. Before we proceed, anything you say can and will be held against you in this transaction. So if you tell me you got money, you want to put an offer of 250, but you got more money, but I don't represent you, I have to be honest. I have to be fair. Listen, you just told me 250 is your offer. I don't represent you. I represent the seller. The moment you told me you have more money, what do you think I'm gonna tell the seller? I'm obligated to tell the seller that you got more money. So to prevent that, Alexis, here's what we can do. I could represent you, or you could find representation somewhere else if you'd like. Simple.
And if you represent her, then you can't sell the.
Then I cannot tell the seller that Alexis has more money. I have to treat everybody fair, honest in the transaction. I have to disclose all type of information except the values. That will be confidentiality or loyalty to
Both sides,
both sides. Does that make sense? So now I represent both.
double ending.
Exactly. Okay, we're good? Thumbs up on that one? Great. All right, and then we have this one, non-agents. Like, wait, how can you be a non-agent? I've heard of secret agents, but not non-agents, right? What is a non-agent? If I told you agent is when you represent somebody, what do you think is a non-agent? You don't. You don't represent. So non-agent, you can be part of a transaction as a non-agent, and I was just explaining that to you. See, before Alexis hired me, I was helping her out as a non-agent. We could put an offer. If you want me to represent you, I become your agent. If you don't want me to represent you, I'll still help you. But I'm not an agent. I'm a non-agent, yes, a consultant, right? Someone who helps a buyer and a seller or a seller, landlord or tenant, without representing them. When you see this non-agent thingy here, think of transaction broker. Look, it's in bold, because especially here in this state, that's what we call it. Transaction broker. I'm a facilitator, intermediator, transaction broker, or transaction coordinator, or even contract broker. Even though there's no representation, I must still follow statutory obligations. So the warnings I gave you up front. I must be fair and honest. Does that make sense? Okay. I'm going to go as slow as possible. So tell me if you're good with everything I said right now, or if you have questions before I proceed. Let me know in the chat if you have questions. We could represent the seller. We could represent the buyer. We could represent both. I just gave you the example. Or we could represent neither one of them as a non-agent or transaction broker.
Then you gain nothing.
Oh, remember I said that compensation does not determine agency.
No, I know, but you wouldn't get it.
So what do you mean you don't get paid?
No,
What do you mean you don't get paid?
there's no-
Am I not? I told you that compensation does not determine agency. Agency is not determined by compensation.
I'm not saying there's, I'm just saying we get paid. right?
Why not? You're still doing the work. You're just not representing the person. You still get commission.
You get commission from that person?
See, here's the thing. If I am helping the seller, look at the difference of words. If I'm helping the seller sell, I didn't say representing the seller. If I'm helping the seller sell, am I not entitled to compensation? I did do the work. As long as we have a written agreement that I'm helping you with the transaction, I'm not representing you in the transaction, and that you're still going to compensate me regardless, I get paid. Compensation is a matter of agreement, not a matter of representation. So if I'm helping Alexis, the seller already told me that if I bring a buyer, I get paid 6%. I'm bringing a buyer. I didn't say I would represent the buyer. I said I'm bringing a buyer. So I still get paid. You got it? It's a matter of agreement. Compensation or commission is a matter of agreement, not representation.
But then you still be an agent, you would just be an agent for the seller.
I told you I'm not representing the seller.
You're not representing either one of them?
I don't feel like representing anybody.
So you have a contract with the seller.
I have a
but-
contract with a seller that I do not represent them, that I'm just helping them, facilitating. That's it. And my commission for doing so is 6%.
And the person who is representing them would have the same contract. It just
Same
would
contract.
say instead of helping represent. them.
Correct, instead of helping, representing. So here's the thing. The difference between these is the liability.
Ah,
If I'm representing you, I'm liable for certain actions. If I'm just facilitating, I'm less liable for certain actions. It's just the level of liability. In fact, we're going to read all this over the next a couple of pages, that you have to disclose this up front before working with somebody, so they're aware of that liability. Okay, I still have to treat everybody fairly and honestly regardless, but then there's different levels of liability based on the type of representation. Okay, now Michelle wrote like a referral agent. No, referral agents cannot facilitate anything. Referral agent, all they can do is refer, and then somebody else will either facilitate or represent that person. I'm not looking at that. I cannot open it right now, Stephen, so I don't know. But again, we're going to go over that in this chapter. I'm just taking several pauses because I want to make sure you guys understand every step of the way. Okay. So the agent advises the client and is entrusted with fiduciary responsibilities to the principal. As I was saying, the client can expect full disclosure. This is big. This is the difference. Clients can expect full disclosure of all relevant or material facts that the agent acquires. I'm sorry. That's for the client. A customer, however, is entitled to material facts and fair and honest dealings, but not advice and confidentiality. So it works exactly the same way, whether you are a client or a customer. The only difference is how much representation are you getting? Okay. How much are you getting from me? Agents work for principals and with customers. Look how it's written. Agents work for principals and with customers. Okay. The agent represents the principal's best interests, not the customers. I'm helping you, but I'm not representing your best interest. If I represent the seller, then yes, I'm protecting the seller's best interests. If I represent the buyer, then I'm protecting the buyer's best interests. It's all a matter of agreement. Okay. Even though the agent has responsibilities towards the principal must also comply with the agency agreement and cooperate with the agent's reasonable expectations, such as not hindering the transaction and acting in good faith. So if I represent the seller, we're going to talk about this later as well. If I represent the seller, can the seller hide information from me? I represent the seller. No. Okay. So it's the same thing as going to the doctor. You have to tell, the doctor will tell you, look, for me to best help you, you got to tell me everything, right? Tell me all your pains, all your aches, all your problems. Tell me so I can help you. When you go to a seller, you tell them the same thing. Look, I'm the doctor. I'm the expert in real estate. Tell me all the problems with the property. Oh, no, I can't tell you everything, because then the value goes down. Listen, it's either you're telling me now or they find out later. Not only do you waste time, if it's after they already own the property, they still have rights to come and sue you. So these are the things that you need to address with your clients. Hey, there's something called statute of limitations, lawsuits. I'll give you an example. State of New Jersey, you got 6 years to sue somebody in a transaction. So imagine I lived in the property for 5 years. All of a sudden I found out that there was structural damage that's from prior to my purchase, but nobody ever told me. If there's a way to find out that the seller knew about it, guess what? I'm suing the seller 5 years later, up to 6 years. So this is why we have to talk to our clients and make sure you get as much information as you can regarding the property. All right, how do you create agency? It could be an oral or written agreement between the parties that can create an express agency, or behavior. actions, behavior or actions of the parties can create an implied agency. Okay, so if it's an oral or written agreement, it's something expressed because it's an agreement. If it's based on actions, is what people expect. Your behavior shows that you would do something, right? So that becomes an implied agency. We're going to go more in detail. State laws usually require real estate licensees to disclose possible agency relationships in a written and signed document prior to any dealings with prospective clients or customers. So when we get to the state portion, for instance, here in New Jersey, we have something called consumer information statement. That has to be provided prior to dealing with your customers or clients. You have to say, hey, I could represent you as a seller, I could represent you as a buyer, I could represent both parties, right? Or represent neither party, just a transaction alone. Here's what you can expect from me in every single instance. Does that make sense? So upfront, I have to warn you what you could expect from me. Every state has some type of form that you must provide or disclose, or even brochures sometimes.
Ooh, write that up, or that already exists?
Already exists, but you have to read it to the client, explain to the client, and then have the client or customer sign what you explain to them. Okay, so express agency. Express does not mean fast. Express means we stated how we're representing. Okay, express means we stated the intention to establish an agency. Okay. Expressed means we stated how we're going to represent you. For instance, I got to tell you up front, Mr. Seller, Mrs. Seller, I could represent you, but in the future, I could represent the buyer as well. If you're not okay with that, you have to choose seller agent only. Does that make sense? If the seller needs to be aware that there's a possibility of we representing the buyer. Okay, so my intention is to work with you as a seller's agent, but in the future, if I find a buyer, I'll represent the buyer as well. Are you okay with that? They say yes, check. If they say no, you have the option to either continue with the client and say, hey, it's seller only, or you have to walk away from that deal. That's it. But you expressed what your intentions are. Okay. A listing agreement is a seller representation agreement that creates an agency relationship between the seller and the broker, authorizing the broker to find a buyer or tenant for the seller's property. Now, some states consider an oral listing agreement binding in certain circumstances, but an exclusive representation agreement must be in writing to be enforced in court. An exclusive buyer agreement representation agreement establishes a buyer brokerage agency relationship, and just like the listing agreement, the buyer representation agreement outlines the broker's duties in finding a home to buy or rent. We're good? Next thing we have is implied agency. So implied has to do with actions. This is when the parties act as if they have mutually consented to an agency, even without a formal agreement. If an agency relationship is legally pursued, the real estate agent may lose the legal responsibilities that might be imposed even without a written agreement. And of course, a real estate agent may also not be paid without a written agreement. Here's an example. If a buyer enters a real estate office to see a property, pay attention, guys. If a buyer enters real estate office to see a property listed by another firm, an agent calls a seller's agent to schedule a showing. So you walked in, okay, Milton, you walked into my office and said, Bruno, I saw a property on 123 Ferry Street, okay? And I go look it up. Okay, that's listed by Weichert. Yeah, I want to see that property, Milton says. We're like, great. I pick up the phone, I call right away. Okay, to schedule a showing. The sales associate drives the buyer to see the house. So I take Milton with me without a written agreement. I took him with me. The sales associate actions indicate the party's intent to form an agency. So at this moment, even though I didn't write anything with Milton, the fact that I picked up the phone and scheduled the appointment, the fact that I went with him created an implied agency. Why is it not expressed? Because we didn't sit down and say, hey, Milton, this is what I'm going to do for you. This is what you can expect from me. If you agree, sign here. We didn't do that. My actions implied that I would represent Milton. Does that make sense, guys? Biggest difference between these two is whether we put it on paper or agreed specifically, or I just took actions that showed that was the intention. We're good? Let me know if you have questions. All right. Now, even though real estate agents must disclose their agency status, consumers often struggle to understand agency law. Buyers may assume that when they contact a real estate sales associate to see a property, the associate becomes their agent. We just went over that. Milton would assume in this scenario what my actions were. Milton would assume that I'm his agent. Even if under the listing contract, the associate, through the broker, legally represents the seller. An illegal, undisclosed agency could arise if the salesperson's words and action don't dismiss this assumption. Okay, so if Milton's looking at a property that's listed by my brokerage, right, and I just get up and take him without signing that agreement or disclosing that information, right, it is assumed that I represent the buyer and my office represents the seller, therefore, or somebody in my office. Therefore, dual agency was created. It becomes illegal, undisclosed dual agency because I never told the seller that I would represent the buyer, or told the buyer that we represent the seller, and put an agreement where the buyer is okay with it or the seller is okay with it. So we're going to talk about that later as well. It's called informed consent. For dual agency to be legal, there must be informed consent where both parties sign saying, hey, it's okay for you to represent the other side. I don't care. Just get this transaction done. That's pretty much what we're saying. All right, compensation. In real estate, compensation does not determine agency. We already said this, didn't we? Very, very important. Compensation does not determine agency. An agent doesn't always represent the person paying the commission. Now, the seller's agency agreement may let the broker use other real estate professionals within the broker's office or firm and others that participate in the MLS. The cooperating broker's compensation usually comes from the seller's commission paid to the listing broker. Any written agency agreements with the seller or buyer should state the agent's compensation after discussing all the options with the client. So usually when you go on the MLS, US Realtors, it will say there how much you're going to get compensated from the transaction. So you'll say 2%, you'll say 2.5%, 3%, 1%, whatever. Okay. So does that mean that you represent the seller because the seller's paying you? No. Okay. Compensation does not determine agency. Samaya, both the agent and the broker agent must watch out for this. The agent and the broker agent? What do you mean? What? Watch out for what exactly? When it comes to implied and expressed, yeah, absolutely. So you got to be very careful in your actions. If your intention is not to represent somebody, That's why you put it in writing. But even sometimes we put in writing, we say, hey, I'm just a transaction broker, right? So not an agent. And that's what we agree to. Sometimes we put that in writing, but then our actions show otherwise. You know how many times I see people like put their transaction brokers? And then every time I call them up or they call, hey, my client wants to see the property again. So wait, is it your client or is it your customer? You see what I'm saying? It's the play of words, right? And guys, if you ever go to court for any reason, right? I hope nothing bad, or if you are going to court, it's because you're the one winning the case, right? But if you ever go to court, you'll see a bunch of stuff where they say, hey, based on Black Law's dictionary. So now we're looking at what the word means in the dictionary. Okay. We can assume one thing, but then when it comes to law, it's another. That's why we must know the difference, especially as professionals. We must know the difference between client and customer. If the intention is to be customers, right, then keep it at that. All I'm doing is facilitating. You cannot go above and beyond for a customer, but for a client, you must go above and beyond. That's the fiduciary responsibilities we're going to go over. You must go above and beyond. All right? You have to be aware of all these differences. All right, fiduciary responsibilities. Very, very important you know these. An agent's fiduciary relationship of trust and confidence means the real estate broker owes certain duties. The duties aren't just moral or ethical, right? That's common sense for everybody. It should have moral and ethics, right? Moral standards and ethics. These are laws defined by either common law of agency or statutory law, as we mentioned before, right? The agent owes the principal duties of care, obedience, loyalty, disclosure, accounting, and confidentiality. Let's start with the first one. What does it mean to care? Who can tell me what it means to care? Wow, is that hard? Is that hard to know what it means to care? Connie says compassion. Right, okay.
To have your client's best interest.
To protect, to have your client's best interest. What else? Wow, so hard. Who has kids or who has pets? Not that I'm putting in the same category, but if you got kids or if you got pets, you know they're like first, right? They're first, above everybody else, right? That's what it means to care. You care so much. You care so much that they are first, above your own interest. Above your own interest. Why are we saying this? What is our interest in a transaction usually? Say it louder. Yeah, because the only reason why we do this is for money. Absolutely. Unfortunately, that's the biggest mistake. Most of us only think of this for money. And when you put money first, that's when you get sued. You understand? Caring means we will get paid in the transaction, but I don't care how much I'm getting paid right now. What I care about is doing a good job and make sure you, Fernando, buy, sell, or rent, accomplish whatever you hired me for. Because if I do a good job, not only am I getting Fernando's money, he's going to refer me to get more money, right? So that's the priority. My clients, a happy client, will be unlimited referrals. Okay? My money is in the back end. Right now, you are my focus. Okay? Now, if you put money first, you will screw up in that deal. Okay? So, what is our responsibility? Why do we have to care? Agents must exercise reasonable degree of care while representing the principal. Principals expect agents to have higher real estate skills and knowledge than the typical person, right? Isn't that what you expect of an agent? Right? Because then I wouldn't ask for your representation. I would just ask for somebody's advice. But I'm asking you to be here with me in this transaction because you are the expert. It's like going to the doctor. I have a headache. I don't need to go to the doctor to figure out how to fix it, right? I'll just go to the pharmacy. I can read what it says, headache pill, right? Isn't that how it is? But then days go by and this headache is still here. Now we have a serious problem that we can't resolve just by reading a label. You guys understand the difference here? Right? You don't need representation for anything. But if you are hiring somebody, you expect that person to know more. In fact, you guys should be sharpening your skills always, and your knowledge over the years. You should be getting better and better and better, getting more knowledge. In the beginning, what do you know? Absolutely nothing. Even after this course, you get licensed, you know absolutely nothing. That's the truth. You know theory, you haven't put it in action. You haven't implemented it yet, so you don't know anything. It's like a doctor right out of med school, like, you're gonna perform my surgery? No, not gonna happen, right? Does that make sense? Right? Now, the agent should know all material facts of the transaction, the physical characteristics of the property, and advise the client by helping the seller set a realistic listing price. You got licensed today. How do you know how to set a realistic listing price? You don't. So you need help. That's another thing about caring. You need to be able to ask for help. Because if you try to do everything yourselves, you're failing at caring right there and then. Okay? You're supposed to discover and disclose all relevant facts. You're supposed to properly present contracts and other documents that the seller signs. You're supposed to know the difference between financing methods. Day one, how are you going to know this? Because I'm going to teach you? No. I'll teach you the basic. I'm not even showing you contracts. I'm not even showing you, I mean, we can go over it, but you'll forget it by the time you get licensed. You understand? We're not doing an actual walkthrough of a house. So what do you know how, like what to look for? You have no idea until you're in the field. And you have to constantly be improving. Now, this also means advertising, holding open houses, helping sellers evaluate purchase offers. That's all your job that you need to constantly improve on. A buyer's agent is legally obligated to assist the buyer in locating an appropriate property, conducting a market analysis in the area and the property, and drafting and negotiating any necessary purchase and sales agreements. So again, it's your job to know how to fill in a contract. What do you know? And even if you did, what are you going to remember? It's already tough to remember 1 + 1 is 2, right? When you get out of school, right? A court may find a representative negligent if they don't reasonably represent their principal's interests. The principal responsibility is any loss caused by the representative negligence and carelessness.
Oh, it's the principal's responsibility?
Oh, sorry. My bad. Agents. All right, obedience. What does it mean to obey? Who's married? Bad joke. I know, bad joke, bad joke. Okay, we're gonna skip that one. What does it mean to obey? Obedience. In real estate, when you represent somebody, some people even left the screen like, oh, okay, I'm out of this. When you represent somebody, you must obey their lawful instructions. Lawful instructions. You cannot follow illegal or unethical orders. Lawful instructions only. Why is this important? Because sometimes sellers go like, hey, I know there's mold in the basement. Please don't tell anyone. I really need to sell this property. I know the mold is there. I'm going to paint it tomorrow. Don't worry about it. Just list the property and don't tell anyone. Do you think that's lawful instructions? It's not.
They can come sue you. It's six-
You need to pass an inspection, and you can get sued if you hide something. Look, if I paint over it, it could pass inspection. Yeah, a good inspector will look for these details,
And if they told you, then you are like, you're liable to that, because you know.
because I know I have actual notice. Very good. Very good. All right. All right, but we're supposed to be loyal. I'm supposed to be loyal. Zabdi just wrote what I was saying. You said be the accomplice, says the right. All right, we're supposed to be loyal to our clients, right? What does it mean to be loyal?
Have their best interest.
Have their back. Have their back. That's our job. So we cannot do anything that would endanger the principal's bargaining position, right? So hiding the molds is a good thing then,
It has to be to the full extent of the law.
to the full extent of the law, as long as it's legal. Yes, you do everything for your client. The agent must put the interest, the principal's interest above all others, including his own. The agent must avoid conflicts of interest. Thus, a sales contract must be negotiated without regard to the commission, and also without the principal's expressed consent. Agents are prohibited from buying the property for themselves or in which they have a personal interest. Brokers and sales associates with a personal interest in the property must disclose it to the buyer. Okay, so when you go in and purchase a property or sell a property, the contract says, is there any party to this transaction, real estate salesperson? If so, then you have a checkbox. You have to let the other party know that you are licensed. Yes, so that's a drawback when you're investing, right? So for 17 years, almost 18 years now, I've been a real estate investor. But I've only been a realtor for almost 8 years. Okay. It took a while for me to cross over that fence because I was afraid. Like when I say I'm an investor, my bargaining position is better than when I say I'm a realtor as well. Right? Yes.
If you're, let's say, married, your spouse is buying an investment property, do they need to disclose if your name is not on it, you're not part of the deal?
As long as you're not part of the deal, they need to disclose. But if you are representing the spouse, then you have an interest.
But if I'm not representing,
If they're buying on their own without my help, not a problem.
and then later on, they want to transfer that title to me,
That's different.
that's different.
As long as you're not involved at all.
Oh.
But if you are involved in the transaction, somehow, either by being one of the owners, as a seller or a buyer, or by representing somebody that's dear to you, right? Then you must disclose. There's a conflict of interest there. Okay. Which brings us to disclosures. An agent has a duty to inform the client of all material facts, reports, and rumors that might affect the client's interest in the proposed transaction or in the property transaction. In recent years, the disclosure standard has been raised to require an agent to disclose items that a practicing agent should know. Underline that. If it's something you should know, you cannot get away with murder anymore. Okay? Whether the agent actually has the knowledge or not, and regardless of whether the disclosure furthers or impedes the progress of the transaction. If you should have known, you must disclose. Whether it affects the transaction positively or negatively, you have to disclose.
What would be something that a practicing agent should?
Right. The most obvious example.
Oh,
The
I'm bad.
most obvious example of a should have known disclosure is a property defect, such as inoperative central air, that the agent failed to notice. Like, how come you don't know that the AC is not working? It's right there. Okay. Steven was like, so I have to test the central air? No. If the air condition becomes a problem, the agent may be liable for failing to disclose a material fact if a court rules that a typical agent in the area would detect and recognize a faulty air conditioner. So, look, there's a lot of things, and I'm gonna have another explanation of this here. No, it is reasonable if you're looking at it, Stephen. If you're looking at it and you see that, for instance, we're in the middle of a summer, right? And the AC does not go below 75, as an example. It's reasonable to assume that there's something wrong. Look, then you know what, Stephen, is like everything else. We're not attorneys, we're not title reps, we're not home inspectors, we're not mortgage loan officers, we're not any of those. But we still need to know the basics and need to be able to identify the basics to make proper suggestions. Okay, so it's not our full responsibility to go and detect and fix it. But again, if you're in the middle of summer, okay, and temperature does not go below 75, right? You see the thermostat, for instance, it says 72, like it's pulling to 72, but doesn't go below 75, right? Then we have a problem. If we're in the middle of winter, it's a little chilly in here, and you see the thermostat is pushing to 70 or so, whatever, it's chilly, something is wrong. Like, again, we don't have to test for it, but there's a few signs that you need to pay attention to. Okay. You cannot tell the seller to turn on the air. No, but this is what I'm saying. Things are noticeable. You're not getting out of your way. Reasonable means you could have seen it. Reasonable means you could have seen it. You don't have to go out of your way and say, hey, it's like 90 degrees outside. Can you turn on the AC, please? But if the AC is off, when it's like 90 degrees outside, it's fishy. You see what I'm trying to say? Like, there's a few things, like, for instance, you get to a basement. It's not our job, guys. You get to a basement. He says, if I come to the house and tell me to turn on the AC, I'll kick you to the curb. Okay. But let's say you get to a basement. Everything is okay to ask. But then again, depending on the type of buyer or seller we're going to get, we might get kicked out of the house. Yes. But if it's suspicious, who do you represent? That's what you got to know. Who you're representing. Whose best interest, right? Well, let's say you get to a basement and it smells like fresh paint. If you don't ask why, right? Even though it's like, oh, maybe they just painted it to sell. Maybe they did. But maybe they painted to hide the mold, right? If it's something that's suspicious, advise your client. Hey, potential client, potential buyer, you should have a home inspection done and you should ask for a mold test. Just saying. The whole house looks like it needs paint. Like, these are the reasonable things to look at. The whole house needs paint. Why just the basement? Why is the basement the only thing that was painted? Possibly. Maybe not. Maybe has nothing to do with it. But these are things that we as professionals need to be on the lookout for. We're not going to inspect it ourselves. We only do a visual inspection. That's our job. And have knowledge and skills. Does that make sense? To identify these things. Yes.
Would you add, like, if you were in that position, you walk in, you're representing the buyer,
Mhm.
you walk into the house and you see the situation, whole house needs painting, whatever you just described, would you ask the seller why, like, or would you keep that to yourself and then discuss it with your client?
Either or. I would try to ask the
would
seller.
ask,
I would try to ask. Yeah, of course. I would always try to ask. But who do I represent? So that's the thing. If I represent the seller, my conversation should have been with the seller and say, hey, I noticed the smell in the basement. Did you just paint the basement? So yeah, is there any reason for it? See, this is the due diligence part. Me asking the seller, is there any particular reason for you to do that? I represent the seller. And he goes like, oh yeah, there's a little bit of mold. I painted over it. Like, okay, just to let you know, Mr. Seller, just to let you know, if there is certain a higher degree of mold that they cannot see or inspect at this moment, but in the future arises as an issue, you could get sued
And lose a lot more money.
and to lose a lot more money than just painting. Yeah. So again, our job, guys, is to get those skills. We're not the home inspector. We're not the loan officer to negotiate to figure out what type of loan, but we need to know the difference between them. We're not the title person, but we still need to know what a title is and how to search the title and look at the title record, right? We're not attorneys, but we still need to know how to prepare contracts. Fill in the blanks at least, right? And know where. So we need to know these things, the basics, right? To advise our clients in the best way possible, whether represent the seller, represent the buyer, or even if you don't represent them, I'll go over this later on as well. And if they're customers, you still have to disclose anything that could affect the transaction that you are aware of. Okay. I'm making you the mold police, not me. Real estate commission, almost all the rules around the United States. Me, I'm not making you anything. But yeah, absolutely. Think about it. Come on, if you see a house that there's tile up here, you guys don't see it, but you guys, there's tile here, and I see that there's a watermark on it. Shouldn't you ask how that watermark got there? Mr. Seller, like, what is that watermark over there? Oh, I had a leak years ago, but it's fixed. Great, it's fixed, great. If it's fixed, why haven't you replaced it? I'm just saying, because if I saw it as a realtor and I represent you, imagine another realtor when he represents the buyer. So if it's fixed, why not replace it? Okay, because if it's not fixed, and again, I see here, a buyer will request an inspection. We'll go deeper into the root of the problem. Doesn't matter who you represent, you should advise them on the best tactics to either sell or buy the property. Okay, if I represent the buyer and I see that, I will tell the buyer, look, there's signs, potential leak, we're dropping this price. Okay, so let's inspect the property for leaks. Are you guys understanding this? All right. All right. There is no obligation to obtain or disclose information related to a customer's race, creed, color, or religion, sex, or national origin. Anti-discrimination laws hold such information to be immaterial to the transaction. Some states have recently enacted laws requiring a seller to make a written disclosure about property condition to a prospective buyer. In fact, the state of New Jersey is one of them. The seller needs to fill out a form called the seller's property disclosure form, property condition disclosure form. So they have to tell the buyer everything they know about the property. Okay, what they don't know, there's an option there that says, I'm not aware, or unknown, or whatever. But whatever they know becomes a statement. And then the buyer receives that, signs off saying, hey, I received it. So in the future, if a problem arises that the seller had already said, hey, there's an issue. If a problem arises, well, the buyer bought it subject to that issue. Those are the conditions. But if it's something that the seller said, no, there's no issue, and then 2 months later of being in the property, there is an issue, they might be able to go after the seller, okay? So some states have already enacted that. New Jersey is one of them. All right, what about this one? Selling as is. Selling as is. Have you ever heard of this before? What does that mean?
But what you see is what you get.
What you see is what you get. Absolutely, right? Anybody else? No returns, no refunds. Okay. Anybody else?
The seller is not
Including defects. I'm sorry.
Yeah, including the seller is not planning to fix anything that's broken.
The seller's not intending to fix anything that's broken. Okay, needs work. Okay. Whatever the condition the place is in, correct? So that means waive inspections and let's not talk about it. You're buying the property as is. That's what it means?
No.
Because that's what a lot of people assume. I'm going to sell it as is. As is means, like you said, current condition. These are the issues with the property. You have to disclose all the issues with the property. And if the buyer still chooses to go through with it, they're buying as is. They cannot sue you for any issues. But if the buyer is unaware of those issues, can the buyer sue? Okay, so a lot of people, again, think as is. It's like when you buy a car, there's something called the lemon law. Like you buy a car as is, they give you like this fake 30-day thing. No, there's not 30 days, there's 60 days. I'm sorry, there's 180 days, 6 months, lemon law, use the car breaks down, something that was a prior issue, I'm coming back, or I'm suing you, right? I cannot just give you a car that the next day breaks down and that's it. House is the same thing. Unless I'm fully aware of all the issues with the property, right? I cannot be buying this property as is. You have to tell me everything. It's falling apart. Great, I still want it. Simple as that. Okay. The home inspection is on the buyer. Yeah, but a lot of sellers, when they do the as is, they expect you to waive the inspections because you're buying as is. No. So selling as is, I made it clear here. A section just for that. Doesn't change contract terms. If the seller means as is, contract provisions about systems and appliances should be changed, and the seller must still disclose the property's condition, and selling as is does not affect the buyer's right to request an inspection. Again, there's a lot of sellers out there that think that that's it. You have to waive inspections. No, it does not change the right to ask for inspections. A buyer can, look, I have this in bold. A buyer can accept the property in its current condition, but must be informed. Okay? If it's reasonable, then the buyer can waive the inspection. Okay? Yeah, well, you can kill the deal, I can kill the deal, absolutely. We can, both of us kill the deal. If I make it subject to anything, you don't have to accept anything at all. That's why it's a negotiation. Absolutely. Absolutely. Okay. All right. Accounting. An agent must safeguard and account for all the monies, documents, and other property received from a client or customer. State license laws regulates the broker's accounting obligations and escrow practices. Most laws require deposits into an escrow account immediately or within a certain time. Get familiar with these two words. One of them is commingling, means mixing client funds with personal or general funds, and this is illegal. Just as conversion is now using the money, that's also illegal. So you gave me a deposit towards a contract, right? I took that money and I ran to Atlantic City. Okay. Not only did I mix your money with my money, now I'm using that money. Illegal and illegal. Commingling, which is mixing, and conversion, which is converting from being your money to being my money, using it. Okay. These two are illegal. All right, and we go over confidentiality, and we'll take a break right after. Confidentiality. An agent can't reveal the principal's personal information, like financial status, for instance. Without the seller's written consent, the agent cannot reveal information such as the seller's willingness to accept an offer below the asking price, or the seller's need to sell it quickly. If the principal is the buyer, the agent must keep confidential information that would weaken the principal's bargaining position, such as the buyer's willingness to pay a higher price. So we did talk about this already. I gave an example when Alexis came into the open house, right? Unrepresented. She gave me information that she had more money. So by disclosing that to the seller, I'm hurting her bargaining position. If I represent is one thing, if I don't represent is another thing. Okay. What is expected to be confidential information can change when the sales agent also represents the buyer in the dual agency. I also went over this, right? Now, depending on state law, the duty of confidentiality may end with the agency relationship, last for years, or be permanent. According to NAR, which is the National Association of Realtors Code of Ethics, any confidential information that a realtor learns about a client must be kept private forever. So if I represent you in the transaction and I am a realtor, because not all real estate professionals are realtors. All realtors have to be licensees, right? But not all licensees are realtors. If you're part of the National Association of Realtors, this is one of the things that a code of ethics enforces. When you learn from a client, it's private forever, unless they say, hey, go ahead, disclose. So a client might say, a seller might say, hey, I have a job that's just got offered to me in Florida and I have to move next month. Take whatever offer, just come on, I need to go, right? They gave you permission to disclose to buyers that you're a motivated seller. Does that make sense? They gave you that permission. Yes? A buyer, the same thing. If a buyer tells you they have more money, then they give you that permission. If a buyer has a need, they gave you that and they tell you, they give you that permission.